Welcome to WG University Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. I am Edward Barket, and I am presenting today with Brian Dunstone from our Philadelphia office. If you would like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website, www.wglaw.com, and you'll find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is who could qualify as a statutory employer under Section 302A of the Pennsylvania Workers' Compensation Act. Let's get started. Brian, would you like to start off?
My name is Brian Dunstone, and as my colleague mentioned, I'm an associate attorney in Weber Gallagher's Philadelphia office. Ed is also in the workers' comp department in the Philadelphia office. We are here today to talk about statutory employers under the Workers' Compensation Act, and you may have several questions about what a statutory employer is, and we're going to get into that throughout the day. If you have any questions after our presentation, feel free to email them at the address shown at questions@wglaw.com. Workers' compensation cases involve several different parties, one of which being an employee. Now, in your day-to-day life, I'm sure you know what an employee is, but under the Workers' Compensation Act, it's specifically defined, and an employee is synonymous with a servant and includes all natural persons who perform services for another for valuable consideration, exclusive of persons subject to coverage under the Longshore Act or the Merchant Marine Act, which are two separate acts covering injuries in the workplace. And each act is different. Now, the Pennsylvania Workers' Compensation Act in particular covers Pennsylvania workers who are injured within the course and scope of their employment. So for our purposes, we're going to focus on this definition of an employee working for consideration that doesn't fall under the Longshore or the Merchant Marine Act.
All right, as Brian just went over with you what an employee is, I'm now going to discuss what an employer is defined as. The term employer is synonymous with master and includes all natural persons, partnerships, joint stock companies, profit, nonprofit, and municipal corporations, the Commonwealth, and all of governmental agencies created by it. So let's break that definition down. It indicates that employer is synonymous with master. Well, what's master? A master is someone having authority over another person. And those include all natural persons. A natural person, in this case, is just an individual. So, for example, if Brian here owned a company, if he owned a company, he'd be a natural person. An individual, he would be an employer who has employees working for him. There's partnerships. A partnership is when two or more people come together to create a business, and their partnership is the employer, and they have employees working for them. There's also joint stock companies. Joint stock company is a company where the stocks are owned jointly by the shareholders. There's also profit, nonprofit organizations, which I think speak for themselves, and municipal corporations, which could be cities, municipalities, townships, the Commonwealth, which is the Commonwealth of Pennsylvania, and all governmental agencies created by it. So those governmental agencies could be departments such as Department of State, Department of Revenue, also Department of Agriculture. It's just some, for example. Now, if that's an employer, we're discussing statutory employer. So Brian, what is a statutory employer?
That's a great question, Ed. A statutory employer is a master who is not a contractual or common law one, but is made one by the Act. And as you can see, there's a citation to the Peck case. Now, this definition essentially is it's a person that's deemed to be an employer when they aren't actually the employer. So let's say you were working for Weber Gallagher. You're an employee of Weber Gallagher. Now, Weber Gallagher as the direct employer wouldn't also be a statutory employer. They would be the direct employer. A statutory employer is someone else, someone that, It's not the name that's gonna be on your pay stub. But it could be someone else, and it only comes up in certain situations that we'll get into a little more. But it's interesting that the term statutory employer, unlike employee and employer like we just went through, the term statutory employer doesn't actually show up anywhere in the Pennsylvania Workers' Compensation Act as far as a definition. It's a case-by-case basis, and it's determined based on specific facts.
Now, as Brian just went over the definition of a statutory employer, what is the impact of statutory employer status? Well, one, and I believe Brian touched on this a little bit, an entity cannot be both a direct employer as well as a statutory employer. If you're the direct employer, you typically have a contract with an employee who's doing work for you, and you're their direct employer. You wouldn't then also try to be the statutory employer. Additionally, an entity found by the WCJ to be the employer is collaterally stopped from challenging that determination as subsequent action by the statutory employer seeking restitution. And as you can see by the slides, there's all the these definitions and what we're discussing are coming from specific cases which we have documented on the slides. But what it means by an employer is collaterally stopped from challenging that determination and subsequent action, that would come up in a case where if there's for example, a contractor and a subcontractor. The subcontractor in a workers' comp case is determined to be the direct employer. They may not have workers' comp insurance, therefore the contractor is determined to be the statutory employer. If it's found that the statutory employer is liable for the workers' compensation benefits of the injured worker, this statutory employer is going to be paying the benefits of the injured worker, which we're going to discuss at a later time. But there's recourse that the statutory employer can then file a separate suit outside of workers' comp law to go after the direct employer who is a subcontractor. And once they bring that separate suit going after them for reimbursement of what they paid out, that employer, the subcontractor, could no longer now say to this separate litigation, hold on, I'm not the employer, they shouldn't be coming after me. Because in the prior case of the workers' compensation case, it was already determined that they're the employer. So once that's determined, they're going to be stuck with that for separate litigation if that comes up once the statutory employer tries to seek the restitution.
And if you're watching this video, you're probably familiar with the term WCJ, but for those of you that might not be, it's a shorthand that we in the workers' comp industry use to refer to the workers' compensation judge, or formerly known as a workers' compensation referee, who is essentially the first adjudicator in a workers' compensation case.
That's correct. Thank you, Brian.
Now, what situations tend to involve statutory employers, and where does it come up relative to workers' compensation cases? Well, in the traditional case, it comes up in the construction settings involving a contractor and a subcontractor, or multiple subcontractors. But it's not only limited to construction cases. It could be any situation involving multiple employers and employees with contracts in between them to do a job. There's specific other factual scenarios that typically come up, but more often than not, it's usually a construction case or like a renovation or new construction where you're building a house. And there's multiple groups such as electricians and plumbers, people that specialize in particular areas with one person at the top pulling all the strings.
Now, the liability of a statutory employer. The statutory employer is liable to pay compensation to employees of a subcontractor unless that subcontractor has workers' compensation coverage. Therefore, as Brian said, the construction industry, if, say, you look out in Philadelphia today, there's all these large buildings, skyscrapers going up. If a construction company were to hire subcontractors for such a subcontractor who's going to perform the electrical work in the building, if they have their employees come in do the work, do all the electric work, and one of the employees gets injured. They're first gonna file suit against their employer, who is the subcontractor. If the subcontractor has insurance, they're gonna be liable, that's workers' compensation insurance, they're gonna be liable for paying the benefits of the injured worker. However, if that subcontractor does not have workers' comp insurance, then the contractor will likely be brought into the case, and they could be found to be the statutory employer. If they're found to be the statutory employer, they're then going to be liable for the injured worker's benefits. If they're liable for the benefits, that could include many things, including wage loss benefits, medical benefits, specific loss benefits, and that includes past benefits, present, ongoing benefits. Now, it indicates the next part of this, the liability, is that a statutory employer who's under this section is required to pay compensation has that right to seek reimbursement of the subcontractor who's primarily liable. And that's section 302B. Now, what that means is what we pretty much discussed 2 slides back, where the statutory employer can then file a separate suit against the subcontractor. And what that will do is they'll bring that suit so that they could get reimbursement for any benefits that they paid to the injured worker due to the subcontractor not having that workers' compensation insurance. And we'll get into later on the slides what else they could try to recoup from the subcontractor.
Now, Ed, you mentioned the last sentence on the slide, a subcontractor who is primarily liable. Are you saying that a statutory employer is say second or third in line for liability for these benefits, or does it vary from case to case?
Well, I guess you could say it always depends on the facts, but in these cases, the primary liability is typically the subcontractor. And then if they don't have it, then it bumps up to who would be next in line. And in these types of cases, who's next in line is the contractor. So that's when the subcontractor would be the primary liable person.
And when you say next in line, is that say a vertical organizational hierarchy with the injured worker at the bottom being an employee of the subcontractor who has contract with the contractor or several others above them?
That is correct. It would be a linear thing, because that employee, the injured worker, would first go after their employer, who is the subcontractor, and then going up from there in that linear line, it'll jump up to the actual contractor who brought in that subcontractor.
Now, in the scenario that Ed just mentioned, a typical case involves a subcontractor and a contractor. But as we just discussed, these statutory employer cases tend to follow a vertical hierarchy, where the injured worker is at the bottom of the hierarchy. They're an employee of a subcontractor. Now, if that subcontractor has a contract with someone else, in that situation, it would be contractor, subcontractor, injured worker. But let's say in the construction context, there's a general contractor, and they bring on multiple different subcontractors, and each one is responsible for a particular aspect of the job. So someone, contractor hires a subcontractor to do roofing work. There's someone that does the framing for the roofing. There's another who also subcontracts with someone who will do the shingles for the roofing, subcontracts with someone else for removal of the old roof, and so on. And so in that case, there's multiple subcontractors. And with multiple subcontractors, it would still go up the vertical chain. Injured worker to their direct employer, who is the subcontractor, and then whoever they subcontracted with above them, each one in line. So it's not just a general contractor and a subcontractor. There could be several subcontractors depending on the overall scope of the project. But I did just want to mention that just because you're a subcontractor to someone else doesn't mean that you can't be a statutory employer.
Now, in those types of cases, Brian, is that all it's not necessarily that when there's a subcontractor, as you said, a roofing, and then they hire different subcontractors, are those all linear that they could go after each other?
Well, it depends on who each entity subcontracts with. So if you subcontract with me and I subcontract with this pen, and this pen subcontracts with a pencil, as long as the contract follows a chain from start to finish. Now, if you as the general contractor subcontract with 6 different people to do 6 different jobs, they aren't all contracted with each other. There's no what's known as vertical privity between them. It's the general contractor would be in privity with each one of those 6 subcontractors, but there wouldn't be vertical privity between those 6 contractors themselves. So in that case, an injured worker of one of those 6 contractors would be able to go after the subcontractor that they're employed by, as well as the general contractor, but not the other 5 subcontractors. Did that answer your question?
Yes, that's good, thank you. All right, section 302A, the Pennsylvania Workers' Compensation Act. This section is coverage of employees of subcontractor, and it also defines a subcontractor and its exception. Now, just to break this up, a contractor who subcontracts all or any part of a contract and his insurer shall be liable for payment of compensation to the employees of the subcontractor unless the subcontractor primarily liable for the payment of such compensation has secured its payment as provided in this act. So I kind of discussed that a little earlier, and Brian even touched on that going down the linear line. If there's a contractor, brings in a subcontractor, and an employee gets injured. If that employee gets injured, he's gonna file suit against his employer, the subcontractor. If that subcontractor has workers' compensation insurance within that state, and in this case Pennsylvania, then the subcontractor, the employer, is gonna be liable. However, if they don't have the workers' comp insurance, then that contractor will likely be brought in the suit and could be found to be the statutory employer. And if they're found to be the statutory employer, they are then going to be liable for the employee's workers' compensation benefits. Now, it also indicates the section 302A, any contractor or his insurer who shall become liable hereunder for such compensation may recover the amount thereof paid and unnecessary expenses for the subcontractor primarily liable therefore. Again, if a subcontractor's found, or if contractor's found to be the statutory employer, they could then bring a separate suit against the subcontractor to try to get reimbursed from any reasonable expenses as well as any benefits paid to that injured worker. And for the purpose of this subsection, a person who contracts with another to have work performed consisting of the removal, excavation, or drilling of soil, rock, or minerals, or the cutting or removal of timber from lands, or to have work performed of a kind which is regular or recurrent part of the business, occupation, profession, or trade of such person shall be deemed a contractor, and such other persons a subcontractor. So that's a lot right there. So just to break that down a bit, it says for the purpose of this subsection, a person who contracts with another, start with 1, to have work performed consisting of the removal, excavation, or drilling of soil, rock, or minerals, or the cutting or removal of timber from lands. This type of situation, I don't believe comes up as much as if you were to have a construction company with a contractor, subcontractor, which would be more number 2, section 2 here. But it could pertain to, say, a land developer comes in, wants to develop land, and that's their primary business. But part of it is that they need that land cleared. So they're gonna have someone come in, remove timber from the land, cut it down, get it ready for the developer to move in. That would fall under section 302A, 1, and subsection I, and the two small i's of the cutting or removal of timber from lands. Now, part 2 is to have work performed of a kind which is regular or recurrent part of the business, occupation, profession, or trade of such person shall be deemed a contractor. Now, in this situation is where, such as Brian already discussed, if you have a contractor who's building a house, you need a roof put on. They will then subcontract to a roofer who will come in. And because part of the house and being a contractor is putting on a roof, that's part of the actual business of being a contractor. So therefore, being a contractor of someone who's performing a job that's part of the business or the trade shall also be deemed a contractor in this case. And there's also the exception, which is the subsection does not apply to an owner or lessee of land principally used for agriculture who is not a covered employer under this act and who contracts for the removal of timber from such land. Now, that was a lot on that one slide because that part, section 302A, is pretty lengthy and there's a lot to it. So we broke it down here into elements. And this one pretty much touches on the case of a contractor. There's a contractor and a subcontractor. So a contractor who, again, is building a house. This time they need someone doing electric work. So they hire a subcontractor in to do electric work. Now, it must be determined whether the contract to have the work performed was of a kind which is of a regular or recurrent part of the business, occupation, profession, or trade of the contractor. In this case, it would be deemed a regular part of the profession or the trade. Here, the contractor is building a house. Part of that job is to do the electric work in that house. So they subcontract it out to this electric company. Now, the subcontractor must not have the applicable workers' compensation coverage or insurance in Pennsylvania. If they don't have that and one of their workers gets injured, when that worker goes after that subcontractor, the contractor is going to be brought into the suit and they're going to be deemed the statutory employer and would be liable for those workers' compensation benefits.
Now, Ed, why does it matter if the subcontractor has valid Pennsylvania workers' comp insurance?
Why does it matter that the subcontractor has workers' compensation insurance?
Right.
Well, it's important that they do have PA workers' compensation coverage, because if they don't, it's going to go up to the contractor, they're going to be liable. If they have some other kind of workers' compensation coverage, such as New Jersey, if the work's being performed in PA and these workers are in PA, then it's not going to apply to Pennsylvania law, and they're going to be deemed not to have any workers' compensation coverage in Pennsylvania. So that's why you want to have that. And we're going to get into the benefits and the liabilities of being a statutory employer. But it's important to always check to make sure that they do have Pennsylvania workers' compensation coverage, because you don't want the liability coming back on you as a contractor. Oh, and this other part is also section 302A, as who qualifies as a contractor, subcontractor. Basically, all the slide's doing here, I'm not going to read through it. If you go back 2 slides, which we're not going to hear, but that big paragraph of section 302A, which we went back and here it is, that pretty much breaks it down, and it just makes it easily more visible for you to review, break it down. Person who contracts with another, 1, to have the work performed, and has the 2 subsections, and then it has 2, which we discussed in the last slide, the regular recurrent part of the business, and the exception down below. So that just breaks it up, makes it more appealing to the eye and easier to understand.
Now, one of the elements that you mentioned, Ed, was a regular recurrent part of the contractor's business. And this could be a point of contention in litigation involving statutory employers. From the potential statutory employer's perspective, they'd want to define the regular recurrent part of their business as narrowly as possible in an effort to avoid potential liability as a statutory employer, while injured workers and their attorneys would argue for a broader definition of what a regular and recurrent part of the business is, because the more specific tasks that fall under the umbrella of a regular recurrent part of the business leads itself to the potential statutory employer, or the target in this case, to be deemed the statutory employer and therefore liable, rather so that the injured worker could go after the statutory employer rather than, say, the uninsured employer's guarantee fund, which tends to take a little longer to get a decision from the judge and to start recouping the medical and wage loss benefits. So one of these cases that came up regarding what a regular and recurrent part of the business is the Salad Works case. Many of you may be familiar with Salad Works. It's a restaurant sells delicious salads and sandwiches and various other items. Well, in this particular case, a franchisor was found not to be liable as the statutory employer when a worker was injured while working for a franchisee. So the Salad Works corporate entity was the potential statutory employer in this case. Salad Works restaurant was the direct employer, and the injured worker was an employee. And the court essentially determined that the corporate entity was not liable as the statutory employer because they didn't subcontract out a regular recurrent part of their business. The corporate entity in this case, the court determined the regular part of their business was in selling franchises to various business owners that wanted to open a Salad Works, while the franchisee, who was actually employing the injured worker, was in the business of selling salads, which is, you would think there's some connection there, but selling entire businesses and franchise models is different than selling salads, even though it was a franchise model to sell salads. So splitting some hairs there, but this just goes to show you how important it is to define the regular and recurrent part of the business. In another case, this Nelson Building Services case involves construction context, general contractor doing roofing work who subcontracted some roofing work out to a subcontractor. And the court found that the general contractor, who had done roofing work previously, had subcontracted out a regular recurrent part of its business. While it wasn't doing the roofing work in this case, as a general contractor, he building structures, new houses, including the roofs, was a regular part of his business. And once he subcontracted with the subcontractor to do roofing work, he was contracting away part of his business, and therefore was ultimately found liable as the statutory employer in that case. Now, another case that came up is the Cargill Meats case, where essentially the potential statutory employer in that case was a meat packing facility. Now, and as part of their business, they would distribute processed meat, in this case, Boston and other locations, and they just had so many truckloads to go out that they brought in another company to make some of the deliveries for them and to transport the meat to other locations. The court found that while they're actually a meat packing facility, that because they transported processed meat as part of their business, that when they subcontracted with this other entity to take some of the truckloads and make those deliveries for them, that although it wasn't necessarily the primary part of their business, it was a regular and recurrent part of their business. And so they were ultimately deemed liable as the statutory employer.
Now, Brian, just in that case, say I owned a meatpacking plant and part of my business, I didn't have a trucking distribution company, but we would need stuff to be distributed. Is that similar to this, or would that not be part of my regular part of my business?
So as with most situations and most legal answers, the answer is going to be it depends. And ultimately, it's going to depend on what the judge determines is a regular and recurrent part of your business. If in your regular day-to-day operations, you don't deliver truckloads of meat from point A to point B, and rather you use UPS or FedEx or any other courier service to make the deliveries for you, arguably you aren't in the business of making deliveries. But if you had done that on occasion, you suddenly stopped doing it, could be a different scenario. So if you did it for a number of years and then company decides we don't want to do it anymore, we're going to let somebody else do it for us, then it's a little bit of a gray area and it's unclear. But based on your situation where you said company does not deliver its own truckloads, I would say that contracting out a trucking service to a different entity would not be a regular and recurrent part of your business, and therefore you wouldn't have potential statutory employer liability.
So you definitely have a good argument there to show that you're not liable as a statutory employer, it sounds like.
Now, it's a different scenario if you did it for a number of years and then suddenly you stop, and a week after you stop, you want to try to make that argument again. While it's unclear how the judge would look at it, let's just say the more time passes between your decision to stop doing a certain part of your business and the time period at issue, let's just say the better argument you have.
Thank you, Brian. Now, discussing in the liability of a contractor deemed to be statutory employer under section 302A, a contractor subcontracts all or any part of a contract, and his insurer shall be liable for the payment of workers' compensation benefits to the employees of the subcontractor, unless that subcontractor is primarily liable for payment of such compensation, has secured its payment as provided for in this act. So, just touching on this again, the liability of a contractor. If a contractor hires a subcontractor, never checks for workers' compensation insurance, and this subcontractor has employees, if one of the employees gets injured, again, they're going after their employer, the subcontractor. If the subcontractor has insurance, they're going to be liable, and they're going to be primarily liable, and they're going to be paying for the workers' compensation benefits of this injured worker. However, the liability of a contractor who's deemed a statutory employer comes in when that subcontractor does not have insurance. So if that subcontractor doesn't have insurance, the statutory employer, who's the contractor, is now liable for payment of the workers' compensation benefits of that injured worker. And again, that could be very costly. Once you go through this litigation, it could be a year at least past the work injury. Therefore, what they'd be liable for is past, present, could be future, potentially future wage loss benefits. Going with the past wage loss benefits, you'd have statutory interest that would be applied to that. You'd have medical benefits, past, present, future, could involve any kind of operations that may be necessary that you're paying for. If there's any loss of use or a loss of a body part, you could be looking at specific loss benefits, as well as even if there's a lump sum settlement, you'd be responsible for paying that lump sum settlement to resolve a case. So that's all liability, and it could become very heavy of a liability financially if you're deemed that statutory employer, where the subcontractor, the employer, does not have any workers' compensation benefits.
Now, in the Cargill Meats case that we discussed before, there was another interesting element that we didn't discuss. And essentially, the meatpacking company, the contractor, subcontracted with the trucking company to deliver some truckloads of meat. In the contract itself, the contract contained language saying that the subcontractor was not actually going to be a subcontractor. Rather, he was going to be an independent contractor in an effort to avoid potential liability for work injuries and other injuries that may come up. Interestingly, the Commonwealth Court determined that the language in that contract didn't render the outside trucking company to be an independent contractor. The court still found the trucking company to be the direct employer and the meatpacking plant, the contractor, to be the statutory employer, and still held them liable despite this language.
Now, the right of a statutory employer to seek reimbursement from the subcontractor is that any contractor or his insurer who shall become liable hereunder under section 302A for such compensation may recover the amount thereof paid and any necessary expenses from the subcontractor primarily liable therefore. So basically what that means is that if a contractor is deemed to be the statutory employer and they paid all the benefits, whether it's wage loss, medical, specific loss, they could now bring suit against the employer who is a subcontractor, a separate suit to recover the amount that they paid. Now, not only will they be able to recover the benefits that were paid, but also necessary expenses that they may have built up over time due to this litigation, which could be litigation costs, including whether it's deposition fees, medical examinations, transcripts, whatever those reasonable costs may be. They could then go after the subcontractor who's primarily liable and try to get reimbursement through a separate suit.
Now, it all sounds doom and gloom when we talk about statutory employers. That is, it's all potential liability. Well, there are some benefits to being deemed a statutory employer. If you were deemed a statutory employer, you would enjoy the benefits of the exclusive remedy provisions of the Workers' Compensation Act, which is another way of saying that your liability would be limited to wage loss benefits, medical benefits, specific loss benefits that are ultimately awarded pursuant to the terms of the Workers' Compensation Act, but you wouldn't be liable in a general civil case. You would also, as Ed mentioned, have the right to seek reimbursement from the liable subcontractors, the direct employers, for any benefits that you had to pay and any expenses that you incurred as the statutory employer.
So the drawbacks of being a statutory employer. First, the contractor is liable for payment of the workers' compensation benefits, which I just discussed. It could become very costly, including if somebody undergoes an operation or just extensive medical treatment, how long they've been out of work with wage loss, and even if there's a lump sum settlement to resolve the case. Now, they always have that right as a statutory employer to go after the subcontractor, the direct employer, for reimbursement. However, there's no guarantee that the contractor would be able to obtain reimbursement from the subcontractor. There's always that risk that when the contractor, who's a statutory employer, goes and files a lawsuit against the subcontractor for reimbursement, that subcontractor could either be out of business or insolvent and just no longer an entity, and there's no one you can go after now. So now you're stuck, one, without getting reimbursed, and with all that money that you paid out because that subcontractor did not have insurance to pay for his employees.
Now, litigation involving potential statutory employers is very similar to litigation involving just a traditional injured worker and direct employer. The only differences are that in the cases involving potential statutory employers, the direct employer is generally uninsured, or they have insurance in a different state. But for purposes of our analysis, if a injury occurs in Pennsylvania and the subcontractor has workers' compensation insurance in a different state, Delaware, Maryland, New Jersey, whatever, you would need to look at the terms of the workers' compensation policy itself to determine if that policy affords any coverage in Pennsylvania. If it does, then you really never get to the question of who is or is not a statutory employer, because there would be valid coverage from the direct employer in the case. However, if the direct employer had insurance in a different state that did not afford Pennsylvania workers' compensation coverage, then what would typically happen is the injured worker would file a claim against the uninsured employer's guarantee fund, who would then turn around and file joinder petitions to join potential statutory employers, such as contractors or other entities working on a job site, in an effort to find if there is a statutory employer. If there is, the statutory employer would jump ahead of uninsured employer's guarantee fund in line. So claim would be against the direct employer. If there's no coverage, then it would go to a potential statutory employer. And if there are no potential statutory employers, then the claim is directly against the uninsured employer's guarantee fund.
And Brian, what is the unemployed insurers guaranteed fund? Or employers guaranteed fund.
The uninsured employer's guarantee fund, more affectionately known as the UEGF, is essentially a fund that or an entity that was created to afford benefits, workers' compensation benefits to injured workers in Pennsylvania. The fund in and of itself is funded or paid for through assessments to employers throughout Pennsylvania. So they have a budget, and it's admittedly somewhat limited. So to bring a claim against the uninsured employer's guarantee fund takes a little longer to litigate the case. And even if the injured worker is successful, it may take a little longer to get any medical benefits or wage loss benefits paid compared to an employer with a traditional workers' compensation insurance policy that's in effect and applicable, where those benefits are generally paid more promptly.
And if I'm correct, in these types of cases, I mean, it always seems like when the UEGF gets brought in, they're always trying to find some kind of statutory employer who would be liable for payment instead of coming from the UEGF.
And I would say that's generally correct. They have every incentive to find any potentially liable entities, whether the direct employer or a statutory employer, because if they could establish that one of those entities is liable and has the ability to pay for any benefits that are awarded, then those entities would pay for those benefits rather than the UEGF, and the UEGF could conserve its funding for other cases where there isn't a direct employer or statutory employer liable and able to pay. Aside from the difference being that the UEGF gets involved in the case and there's joinder petitions and the litigation takes a little longer, the litigation itself would proceed as normal. The parties would take their evidence. The injured worker would usually testify. There would be medical evidence, either reports or depositions, and potentially fact witness testimony taken in the case. And then ultimately it would get before the workers' compensation judge, who would make a decision. Now, in cases involving several potential statutory employers, it's possible that there could be bifurcation issues. And by bifurcation, I mean that the judge would agree to determine the liability of a statutory employer before actually determining whether there was a work injury or a disabling work injury in the case. And that'll vary from judge to judge, and usually depends on how many additional parties or potential statutory employers or targets are joined into the case. If it's just one, it doesn't really delay the litigation that much. But if there's 5 or 6 potential targets or statutory employers, then if each one of those entities wanted to get a medical exam it gets expensive, it drags the litigation out a little longer. And so in those cases, the judges are typically more inclined to bifurcate those issues. And as I just discussed, bifurcation is essentially the judge agreeing to split off one or several issues from the case in general and agreeing to determine those issues in an effort to streamline the litigation, save everyone some expense, and come to a decision more efficiently.
Now, how to avoid statutory employer liability. The easiest way to avoid becoming a statutory employer and having that liability is that if you're a contractor and you're going to subcontract some of your work, always request that the subcontractors maintain valid Pennsylvania workers' compensation insurance. And I'm not saying don't just ask, do you have Pennsylvania workers' compensation insurance, or make that a requirement. You should ask for their policy. Take a look at their policy and read it. Don't just make sure that they have some form of workers' compensation insurance. If the work's being done in PA, you want to check to see what that policy covers. Make sure that policy covers Pennsylvania. And by doing that, that's the best way you could avoid statutory employer liability. And when you're looking at it, make sure that you're looking at the time frame that it's valid. And so if the work's being done in 2019, you want to make sure that the policy covers 2019.
Now we'll get into a couple hypothetical scenarios, and I believe we have 5 hypotheticals. If you have questions about any of these, feel free to send an email to questions@wglaw.com, and we'll be happy to answer them as best we could. In this hypothetical, let's assume there's a general contractor who has valid Pennsylvania workers' comp insurance and a subcontractor who has valid Pennsylvania workers' comp insurance, and that an injured worker was doing work for the subcontractor in Pennsylvania at that time. In this situation, who would be potentially liable for the worker's injury? Well, in this situation, the subcontractor in this case has valid Pennsylvania workers' compensation insurance coverage. So this is a typical run-of-the-mill case involving an injured worker and an insured direct employee. You won't get into any statutory employer issues in this case. There's valid Pennsylvania insurance. Litigation would proceed either by accepting the claim or by injured worker filing a claim petition against the direct employer, and it would just move forward at that point. No potential statutory employers in this case due to the subcontractor having valid insurance.
Our second hypothetical is a general contractor who has Pennsylvania workers' compensation insurance, contracts out to a subcontractor who does not have workers' compensation insurance in any jurisdiction. So the injured worker who is performing duties for the subcontractor in PA was injured. And in this situation, the injured worker will file suit against the subcontractor. Subcontractor is primarily liable. However, in this case, they don't have workers' compensation insurance. So this is the kind of case where the UEGF will be brought in, and then the general contractor will be brought in to be deemed a statutory employer. If that general contractor, which likely will be deemed a statutory employer in this case, will then be liable for the coverage under the Pennsylvania Workers' Compensation Act for the injured worker. So the general contractor will be deemed statutory employer, and they will then be liable for benefits to the injured worker if their claim is granted. However, as we discussed, the benefit of being the statutory employer is that employee, the only right to file any suit against the general contractor is through the PA Workers' Compensation Act. They can't bring any other suits against them. The general contractor, if the claim is granted and has to pay for the workers' compensation benefits of the injured worker, can then go after the subcontractor who was the employer and primarily liable to get reimbursement of any benefits paid, as well as any expenses, reasonable expenses that they paid during the litigation of the claim.
Now, in this hypothetical, general contractor has valid Pennsylvania workers' comp insurance. Subcontractor has workers' comp insurance, but they're insured in Delaware, not in Pennsylvania. And injured worker gets hurt in Pennsylvania while working for the subcontractor. In this situation, the general contractor has statutory employer liability. They'll likely be brought into the case. That's because the subcontractor doesn't have valid Pennsylvania workers' comp insurance. If we assume that the Delaware workers' compensation insurance policy doesn't afford any Pennsylvania coverage, then this is a situation where the injured worker will bring a claim petition against the subcontractor. Once they learn that there's an issue regarding whether there's Pennsylvania insurance coverage, the injured worker would then file notice of claim against the UEGF, and who would then, in all likelihood, bring in the general contractor under a statutory employer theory. And same liabilities and benefits to the general contractor in this case, if they were ultimately deemed the statutory employer. But the key in this is, even if you have workers' compensation insurance, if the subcontractor does, if it's not Pennsylvania workers' comp insurance, or it doesn't afford Pennsylvania workers' comp insurance coverage, then it's as if you didn't have insurance at all.
All right, our fourth hypothetical is a project manager this time is insured with Pennsylvania workers' compensation insurance. They hire a subcontractor who's subcontractor A. They have insurance through Pennsylvania workers' compensation, or for Pennsylvania workers' compensation insurance. And subcontractor B, who was hired by subcontractor A, and they do not have workers' compensation insurance. And there's an injured worker who was performing duties for contractor B in Pennsylvania at the time of his injury. Now, this type of case is what we discussed earlier, where it's a linear relationship. You have the project manager who hires a subcontractor. Subcontractor A then goes ahead and hires subcontractor B. So in this situation, the employee will go after subcontractor B. Since subcontractor B does not have workers' compensation insurance, the UEGF will be brought in, the subcontractor and the project manager will be brought in, could be deemed statutory employers. But since subcontractor B does not have workers' compensation insurance, you go up one, subcontractor A, since they hired subcontractor B and they have insurance for Pennsylvania's workers' compensation benefits, they then will be deemed liable as a statutory employer in this case. Now, is there a benefit at all for project manager to also say, I'm also a statutory employer, I'm just not liable for paying because subcontractor A is the one who'd be liable in this line? Well, the benefit for the project manager would be that being a statutory employer, subcontractor B, or the employee, I should say, the employee who is injured can't come up to the project manager in any lawsuit outside of workers' compensation. Their sole recourse against the project manager would be through the Pennsylvania Workers' Compensation Act. And then, of course, subcontractor A can then go after subcontractor B to get any reimbursements for benefits that were paid, as well as any reasonable expenses.
And it appears there's a typo on this last hypothetical. Similar situation, general contractor has Pennsylvania insurance. Subcontractor A was hired by the general contractor. That should say does not have Pennsylvania workers' comp insurance. And subcontractor B, who was also hired by the general contractor, does not have Pennsylvania workers' compensation insurance. Injured worker was injured while performing duties for subcontractor B in Pennsylvania at the time of injury. In this case, so general contractor sued two subcontractors, but no vertical privity between subcontractor A and subcontractor B. This is a situation, let's say, construction project, and two subcontractors are brought in, one to do plumbing, one to do roofing work, two completely different types of work involved. and each subcontractor has a contract with the general contractor, but no contracts with each other. In this case, where the injured worker was injured while doing work for subcontractor B, since he doesn't have insurance, the injured worker will bring a claim against subcontractor B. Once the injured worker learns that there's a insurance coverage issue concerning subcontractor B, they'll bring a claim against the UEGF, who will turn around and try to bring in additional statutory employers, including the general contractor in this case. Subcontractor A, since they aren't in vertical privity, they didn't contract any of their work out to subcontractor B. They really have nothing to worry about. They might still get brought in initially in the case, just because they're affiliated with the project, but ultimately they should be let out of the case or dismissed because they didn't subcontract a regular recurrent part of their business. They actually didn't subcontract any of their work to subcontractor B. So the general contractor would still have the same statutory liability exposure, same liability, same right to reimbursement as they did in the prior hypotheticals. But in this one, this hypothetical is really to demonstrate the subcontractor A, although they also are a subcontractor on the project, really doesn't have anything to worry about in this case.
So what is the best way to prevent situations of becoming a statutory employer, such as based on the hypotheticals we just went through? The general contractor or the project manager could have requested proof of workers' compensation insurance from the subcontractors at the time they retained them. By doing that, and by asking for the actual policy, making sure it's valid, it's during the right, covers the time period, and that it's for Pennsylvania workers' compensation, it will prevent these statutory employer liability situations.
Thank you for attending our webinar titled Who Could Qualify as a Statutory Employer under Section 302A of the Pennsylvania Workers' Compensation Act. You can learn more about this program and all other Weber Gallagher events by visiting our website at www.wglaw.com. Thank you for attending our presentation. If you have any questions, please send your questions to questions@wglaw.com, and feel free to check out our website. If any questions come up, send us an email, give us a phone call, and we'll get back to you as soon as possible. Thank you.